Good morning, everybody. Welcome to the Law News Network. I'm Jesse Weber, and thanks for joining us today. We are in day 4 of the Adam Matos case out of Pasco County, Florida. For anybody who's just joining us or for anybody who has been following this case, here's a quick recap of this case. Adam Matos has been accused of brutally murdering his ex-girlfriend, Megan Brown, her 2 parents, Gregory and Margaret Brown, as well as her boyfriend, Nicholas Leonard. Now, it should be noted that Megan was the mother of Matos' son, a young boy who was 4 years old at the time, named Tristan, and he's going to play further into this story as well. The prosecution has said that the evidence that they will present in this case will show that this is a guy who killed these 4 individuals, tried to clean it up, and used their cars, their credit cards, and sold their belongings and tried to escape. In fact, the prosecutor, you see him right there in his opening statements, he said, if this was a book, the title of the book was, "I Almost Got Away with It." Mr. Matos, if he is convicted, faces the possibility of the death penalty. Now, yesterday was some interesting evidence coming forward by the prosecution. Again, they're still putting on their case, and we'll talk about what the defense is doing because they elected not to put forward an open argument, and they haven't really done very in-depth cross-examination, so we're going to get to that in a bit. But yesterday, we saw the testimony from a forensic investigator, Susan Miller, and she showed that there was blood on various items in the house, including on a mattress, a white fitted sheet, and clothes that were both stuffed inside a garbage bag. There was blood on plastic storage bins, a white basket, and stacked cardboard as well. We also saw the testimony of Dr. Noel Palma. Now, she's a forensic pathologist, and she basically investigated and examined the 4 different bodies in this quadruple homicide. And what we were able to learn, or what the jury was able to learn, because remember, they're hearing this for the first time, the benefit of the research and watching LawNewz that we have here. They found out yesterday that Margaret died from blunt force trauma to the head and asphyxiation with a plastic bag. Nicholas died from blunt force trauma, and Megan and Gregory died from gunshot wounds. Now, we'll talk about that. Also, it should be noted that there were several guns as well as a hammer that were thrown into the canal, that were found in the canal behind the Browns' house. And the hammer is important because what we've heard so far is that these injuries, these blunt force trauma injuries to Nicholas, a hammer. So we have a lot to digest in this case, a lot to discuss, and joining me now to talk about this case is criminal defense attorney David Pietro. David, good to see you again.
Good morning. Thanks for having me.
Let's talk a little bit about what happened yesterday. We saw the testimony of this forensic pathologist talking about the manner in which these 4 individuals died. Explain to us, just from a general standpoint, why is it important for the jury to hear the gruesome nature of these injuries? Is it not sufficient just to say how they died, but a thorough examination of the exact cause of death? Why is that important?
It's important in Florida, just like many other states, because this is a death penalty case. So the depraved heart and the brutality of the crime, if he's convicted, is going to then carry over to the second phase of the trial, which will relate to the aggravators for death, the death penalty. So it seems like the case is a pretty strong case factually for the prosecution, but they're pushing for the death penalty, which usually forces defendants to go all in. They have nothing to lose at that point. So all these key evidence on the brutality and how vicious and violent the case was is going to likely play into the second part if he's convicted of the penalty phase of the trial.
Speaking of the brutality, it was said yesterday by this medical examiner that the injuries to Nicholas Leonard, it was possible that he was hit 21 times after he was dead. It's possible that these injuries that he sustained, and he had, really a fractures to his skull. It was hard to piece the skull together. I mean, it was really severe injuries to his face and head, that if it's possible, it's possible the idea that he was hit multiple times even after death. Does that not suggest that this was a personal crime, that this was a personal attack, that this was somebody who had something out against Mr. Leonard? I mean, again, I'm just speaking here, but we know that Mr. Matos was Megan Brown. They were in a relationship. Nicholas Leonard was now in a relationship with her. So it kind of can help the prosecution create a story here.
It shows how violent and how vicious this actual crime was, and how it was driven by motivation and the intent to do it. Because if you're there to just rob somebody and steal their jewelry or something like that, you don't hit them 21 times after they're dead. When you're there to kill them, you thought about it, it's something you wanted to do. This is the kind of things you do after the fact the body's dead and you brutalize it. Or, other cases like we had the one in Mississippi where they set the body on fire. These are the kinds of acts that people look for, the prosecution looks for to show that this person is worthy of the death penalty. And this is not an ordinary murder, if you can call any murder ordinary, but it's not ordinary in the sense of this person actually went over and beyond and was very vicious and had the propensity to kill like the way they did.
I have a question about this, the way that they were killed, and it also ties into the defense's strategy here. We'll get into the defense's strategy in a minute because we haven't had a chance to talk about this case yet. But, okay, so we know that Margaret Brown showed up later to that house because she had a shift, she was working, and then she came home. But the three people that were killed, it seems at the same time, were Megan, Gregory, and Nicholas. The idea that two suffered injuries from gunshot wounds and one suffered injuries from blunt force trauma with what appears to be a hammer, if you're the defense attorney, can you we saw this on our message boards yesterday, people were asking questions about this, the idea of committing these three attacks at the same time, and maybe there was a struggle, maybe there wasn't, but there are three different attacks, and one was using a different weapon. How is it possible someone could do that in the same kind of areas? Is that the way that a defense might jump on that it's not possible for our client to have done this? Maybe there was multiple attackers because he couldn't have killed all three people. One of them would have ran away, or there might have been a struggle. What do you make of that?
Well, I mean, when you don't have a lot to work with, you got to work with something, right? But it is something to work with. It raises the issue of maybe there was two people, three people, and maybe the defendant isn't the one that actually committed the murders, was just present at the time. It could create doubt. Whether that rises to the level of reasonable doubt, that's up for the jury. But it's something to work with. You're right. I mean, usually if you're there to kill somebody with a firearm, you're going to kill them with a firearm. You're not going to then use a claw hammer to kill the fourth person. So it raises an interesting issue. It
does. Let's talk about the defense, because as I said, we haven't had a chance to talk about it. I've asked every single guest I've had on about the defense's strategy. As far as I've seen, it's kind of rare, in my opinion, correct me if I'm wrong if you've seen it, for a defense to, in such a kind of case, to reserve their right for an opening argument until the prosecution closes their case. And they said they would only reserve their right for a closing argument if they decide to put on a case. They might not even decide to put on a case. And what we've seen so far is they haven't really cross-examined witnesses very thoroughly. Then again, we haven't really gotten into eyewitnesses. We haven't gotten into family members that much. So what do you make of their strategy as of today?
It's an interesting one. I've actually done this before in Florida, where you waive your opening and you wait. But if you do that, that's suggesting to the jury that you're going to put on a opening statement. Otherwise, you would just do the normal opening statement. So hopefully they have some sort of strategy, because if he's convicted, this is going to come back on a 3.850, which is Florida's rules on ineffective assistance to counsel. So hopefully they have a strategy on exactly what they're going to do. And I gather that the defendant's going to testify and probably come up with a story that is sort of outside the box, which puts the prosecution on their heels on how they're going to cross-examine him and what his likely scenario or allegations or his he was on the night of crime is going to occur.
So you think they're going to put him on the stand? You think the defense is going to put their client on the stand?
100%.
Really? What makes you say that? Because I was talking with Aaron Keller yesterday, and we were talking about there's a significant danger about putting any kind of defendant on the stand. But let's not forget that Mr. Matos does have a past history. He's been involved in different instances in the law. We know that he's had incidents in the past, and sorry about that. But yeah, no. So he's had problems in the past, and that could easily be brought in by the prosecution. Those evidence of bad acts. But I'm curious, you think they're going to put him on for this kind of case?
I bet put all my chips on the mahogany. There's no doubt in my mind. I mean, it's sort of normal in Florida. I don't know if this is consistent since I practice in South Florida. This is the Tampa Bay area. But I've never, when I was a prosecutor, I never had a defense, and it's happened to me a couple times, waive opening and not do their own side of the case. And any case I've ever seen that wasn't mine, that's exactly what happened. So why you would waive opening to then not put on a case would be counterintuitive. So to me, it's exactly where they're going.
I have to agree with you in this sense because I'm listening to this case, the jury's listening to this case. Why would a guy who maybe had nothing to do with this, why would he be living at the house? You know, why would he be using their cars? Why would he be using the debit cards? Why would he be what seems to be cleaning up things? Why would he be ordering up pizza? Now, if Matos can come forward and say, "Let me explain my side of the story," I would love to hear what that story is, but that might be his saving grace. And then let's also add on to the fact that in the events leading up to this trial, because we had the understanding, or that what we thought, was that they were going to point the finger at somebody that was stalking Megan Brown, a third party suspect. We haven't heard anything about that in the trial yet. I thought they were going to bring that up in their opening argument. There was no opening argument. So you're saying that maybe it's possible they'll bring him on the stand, he'll talk about this, maybe this third party, and that might be their strategy moving forward.
That might be all they have. And this is probably something they thought about, looking at the evidence that the prosecution's got them tied up pretty tightly, that they utilize their right to be silent, and they're going to bamboozle everybody with what their side of the story is and see if that raises reasonable doubt in this case.
We are thinking we're going to see some testimony today from family members. We might see in the next couple of days people that knew about their relationship. Now, we know about that 911 call, that Megan Brown made on the day, August 28th. We believe that's the day that she and her family and her boyfriend at the time were killed. That morning where she made that 911 phone call saying that Adam Matos threatened her with a knife, that's in the record. That's fact. We know that. If we hear witnesses testifying to their relationship and just saying, it was a volatile relationship and was a violent guy or things of that nature, what would you do as a defense attorney to really attack their credibility? Would you say you don't know their relationship as well as you thought, or put the blame on Megan in some way? How would you do it?
Yeah, I would poke away at all those things. It's just general knowledge without specificity based upon one person's side, which is a family member who's now deceased, and you believe that the person that's standing trial is the one that committed it. So I would just poke away at them gently. You don't have to go aggressively, but gently poke away at whether they actually had knowledge, or was this just a relationship that had problems like many other relationships.
And what about Ryan McCann? Now, Ryan McCann is the neighbor in this case, and he's going to have some really crucial testimony going forward because he hung out with Matos after this August 28th date. While Matos was living at that house and ordering pizza, he went out to a bar with him. Matos came over and hung out with him, and even one person, they were hanging out with a few other people, and somebody that was in their party said that something smells like someone died here, and Adam Matos made a face. So the idea that Ryan McCann's going to be such a crucial witness for the prosecution, what does the defense have to do to dispute his testimony? I mean, and I'll add that further. You're going to hear a lot of testimony from people about that smell. Everybody's talking about that smell. How would you, we assume it's decomposed bodies, but how would you create doubt in the minds of people for that smell as well as Ryan McCann's testimony?
I would use Ryan McCann if I was the defense. I would show that he was able to go to a bar, hang out, be perfectly normal, and wasn't concerned about somebody dying and things like that. So I would try to interloop him in a way to show that it wasn't Matos, because Matos was acting normal and nothing out of the ordinary.
That's so interesting because they went to play pool. I think they played like 5 games of pool. He was drinking. He was ordering pizza to the house. I mean, the idea that someone who committed these quadruple homicide in such a brutal fashion was having the bodies just hang out. There was blood all over the place and just, acting as if nothing happened. I could see what the defense would say here. I am curious, however, do you think there was a discussion at some point that by the defense that maybe we should see what maybe this insanity defense to do here, or maybe you think they might have consulted with them? I mean, obviously, we don't know what they know. We don't know what really happened that night. But the idea that you could show, with the insanity defense show here, that here's a guy who really was living his life as if nothing happened. Does those kind of cases play in the insanity defense?
For Florida, no. The insanity defense is near impossible. So we have the much higher standard for insanity. If he knew the difference between right and wrong, whether he was suffering from some mental deficiencies, really won't make a difference. So I think insanity is a very tough play in Florida, so I don't see that happening.
What about for the death penalty phase? If he is convicted, can you show somehow, if you're the defense, Look, this guy, he has a mental deficiency of some kind. He's not on the same level as everybody else. And the guy who committed these crimes thought that there was nothing wrong. It would be unjust to sentence him to death because he's suffering from some sort of mental deficiency. Is that an argument? We kind of saw this a little bit in the Luis Toledo case, again out of Florida, where they thought that, the defense tried to said he suffered from trauma to the head. You know, he had problems with impulse control. He had different issues because of injuries to his mind. Now, I don't know about any injuries to Mr. Matos, but the idea that this guy, if he's convicted, he was living as if nothing happened, can that be used to the defense's advantage in the penalty phase?
Oh, absolutely. In Florida is now, maybe about a year ago, the Supreme Court has said that you need a unanimous 12-person recommendation for death in order to sentence it to a defendant to the death penalty. And as crime comes down, you'll see it correlates with the general population's belief in the death penalty. As crime goes up, you'll see that the populations usually agree more with the death penalty. So since crime is down in Florida at record level lows, it's harder and harder to actually sentence somebody to death, even though you got them locked solid on a guilty verdict. Interesting
you should say that, because in the Luis Toledo case, they all voted unanimously that this guy committed that brutal murder of his wife as well as the two children. But despite that, even having such a strong case like that, they couldn't find him eligible for the death penalty. It was 10 in favor of the death penalty, 2 said no. So I agree with you. It's not so simple to say that, despite, even if he is convicted, the heinous nature of this crime. What I find interesting about this case is that I don't see as of yet so much DNA evidence linking him to the murder. In other words, I don't see so much his fingerprints on murder weapons or some sort of testimony linking him to the actual crime. What we see is so much of it happening after the fact. We see so much of his behavior and what he did after the fact. You know, we knew that he was calling Megan 120 times from the night of August 27th until the afternoon of August 28th and never called her again. Then he was living at the house. He was ordering pizza. He went to buy a shovel. He was cleaning things up. There was garbage bags outside. He left the crime scene. He escaped the crime scene. So much happened after August 28th that it begs the question. I think it's interesting if you had a case where this case was he committed these crimes and then immediately called the police and said, I stumbled upon this murder. He seems to be the prosecuted right now for everything he did afterwards. What do you make about that?
Because everything he did afterwards is totally bizarre.
Yeah.
So many of these murder trials where you get the videos of a Home Depot or Walmart where you see him going buying the supplies and the bags and the shovel, it just looks really bad. I mean, why all of a sudden after a murder you're buying a shovel? I mean, the coincidence, I've maybe bought one shovel in my life. If it happened the day after there was dead bodies in my house. It begs the question as to why there's a coincidence here. So it's all really good evidence, and it really plays well with juries.
Especially since I thought the prosecution did a fantastic job of laying out what they called a table of contents of where they see their case going. Really, really strong. And if they can back it up by the proper evidence and testimony as they've done so far, it seems to be a very strong case against him. I'm very curious, though, when you hear these kinds of cases, what do you think that the defense will need to do in terms of the more eyewitness testimony, in terms of people who were walking by and heard gunshots, the people that walked by, I know there was one person who was walking her dog and saw someone that appeared to be Matos cleaning out the garage with a hose. These evidence, or even the pizza delivery guys, or the people that tried to pick up the television set that Mr. Matos was trying to sell. They said that you're going to hear testimony where they said they tried to pick up the television and he wouldn't let them into the house. You're a defense attorney. How do you attack all these people that were in the area or had interactions with him?
Well, so if you're the prosecution, you're creating a timeline. You're putting him there before the murder, during the murder, after the murder, and then subsequent for any cover-up. If you're the defense, you're trying to just pick away that they didn't see the murder. They cannot identify him as the actual person who committed the crime. So you're picking away and also people's memories, especially remembering somebody washing out a garage or doing this and that, those kinds of things fade because they're not very particular in our minds. Is you see your neighbor every day walk the dog, whether it was on Tuesday or Friday, you can't remember. So you'd be surprised that witnesses don't have a clear memory sometimes as to the time they did it, how and what occurred, because it's part of their normal daily life. So they'll pick away on the particularity of their memory, I think.
Especially for the person who saw the hose, because they couldn't positively identify Mr. Matos. So I think the defense is going to pick up on that, and also maybe, as you said, say, are you sure it was that time frame? Maybe it was a week before. You might not remember. So I think it would be interesting to do that. Aaron Keller had a great theory yesterday, or a theory that the defense might move forward with, and I want to hear your thoughts on it. We don't know exactly what happened. A motive really hasn't been put forward. We can kind of surmise a motive here, that that Megan Matos were in a volatile relationship. We seem to have the idea that he had a difficult relationship with their parents in terms of he was supposed to be providing some sort of support or help, and he wasn't really doing that. I think there was issues about the raising of Tristan, the 4-year-old son. Aaron said, couldn't it be possible that the defense would put on an argument that this was a hotbed of emotions, tempers were raising, and it just erupted in that house, and who knows if who struck who first and who initiated this violence first, and perhaps Mr. Matos was in some sort of self-defense position, and the defense would try to do this to show that it wasn't maybe such a high degree of murder, but try to show it was more heat of passion or something like that. What do you make of that argument?
It's not a bad one, but then they're going to have to really show, if you got 4 people on one, the one better have some injuries, some bruises, punches, scratches. If you can't show that, you're going to have a tough time showing that it was a self-defense. Now, on the flip side, on the emotional part, that it was such heat of passion that it was a second-degree murder, that's a good avenue, because that gets you out of the death penalty and gets you as to just a life sentence versus death in Florida. But still a tough road to go with 120 phone calls and all the things that happened prior to show it wasn't like that he just showed up and things erupted, that it seemed like it was a building and a piling on effect until it actually occurred.
Listen, David, you're a great attorney. I know this would have never happened under your watch, so I'm going to ask you. Matos gave an interview with the Tampa Bay Times while he was in jail. Now, I don't think he was represented. He might have been represented. My question is, how much is this going to hurt him moving forward? Because we know you're not supposed to say anything to the media or detectives until you're represented by some sort of attorney. And the idea that he gave statements to the Tampa Bay Times saying he had nothing to do with it. He said the last time he was at the house was August 28th, the morning of, which, as we can see so far, probably isn't the truth. And, he also pointed the finger at someone else. How much is that interview going to hurt him in this case?
Oh, it's going to hurt him, especially if he testifies. So if they waive the opening and he's going to testify, whatever he says better be aligned with what he told this reporter. It'd be interesting if the reporter becomes a rebuttable witness. I know sometimes reporters claim the First Amendment defense and they don't want to be witnesses in cases, but the reporter now becomes a witness in this case.
Yeah, I can only imagine that how much, if they really do put him on the stand, can you give us an idea how much a defense attorney prepares their client for the stand? I mean, really, for this kind of case, it might all depend upon his testimony. We saw testimony in Jeffrey Willis where he tried to, out of Michigan, where he went on the stand. Didn't work out so well for him. He was convicted. So how important is it? I mean, what goes into that?
Oh, you have to play devil's advocate. Luckily, you have 2 lawyers on a death penalty case, so you probably should have one that's, coaching you through your direct and one that's tearing you apart on your cross. So hopefully they spend hours and hours and hours about how they're going to come at him on his cross-examination. But still, there's nothing like game day. You never know how somebody's going to act on the stand, how believable they're going to be or not.
Yeah. David, I have a final question for you. We saw testimony yesterday that there was blood all over. There was blood on multiple items in the house. That seems to suggest that this was a sloppy cleanup, or it seems to show, that whoever did this really didn't take the time to wipe the area down, get rid of it. But we also saw some items with clothing on it. We saw some items with blood on it that were put in garbage bags. What does this suggest to you as maybe as the defense in this case or the prosecution in this case, that there was blood around this house?
Well, it just shows that it was sloppily done. It was probably done out of anger, passion, things like that. It wasn't like a a calculated killing. It was more of a brutal, emotional type situation, and that the cleanup was he was no pro, so to speak, at this, and it happened, and he didn't know how to react to it, and he tried to clean it up, and he was sloppy about it.
Interesting. So in other words, I want to just pick on one point that you said, not a pro. So it would suggest whoever did this might have been their first time in this kind of situation, killing.
Right, right. This
Yeah.
is not Dexter, right? This is
Yeah.
somebody that's somebody that this is his first go around.
And hopefully his last. David Pietro, thank you so much for joining us here on the Law
Thanks
News
for
Network
having
to talk
me.
about this case. Thank you.
I know.